All right, good afternoon, Chair. Board and staff members are accounted for. Lobby is open and the recording has begun.
All right, thank you, Dustin. Good afternoon, everybody. This is David Poston, the board chair. I'm joined with members Russ Hauge and Ollie Garrett for a special board caucus meeting on July 22nd, 2021, to discuss an interpretive statement, what we're calling for allowable practices for a holder of a marijuana processor license. This is an interpretive statement, which is the suggested way for the agency to advise the public of its current opinions, approaches, and likely courses of action. I'm going to turn it over now to Director Rick Garza, who has staff here with us today. What I'd like us to be able to do is I've asked Rick to have staff do a briefing of what's in this statement, and then we can turn it over to the board for questions. So, Rick, why don't you take it away?
Thanks, Chair Postman and board members, Garrett and Hauge. Before I hand this over to Justin to just walk through the interpretive statement, I just want to take a moment to thank Justin, Kathy, Chandra, and Kendra, who've been working on this for weeks, and also thank Bruce Turcott with the AAG's office, who provided us with a great legal analysis and advice about this issue. And then, of course, I want to thank the individual board members for showing patience through this process. But with that, I'll hand it over to Justin. Justin, would you please share the statement?
Absolutely. So good afternoon, Chair Postman, members Hauge and Garrett. So thanks for allowing us some time this afternoon. So I'm bringing to you today a follow-up to a previous board caucus, primarily the one on June 16th. As everybody's aware, the agency received numerous comments and various feedback on a issue that was, you can call it polarized or controversial, but there was a lot of differing opinions and surrounding the creation of Delta-9 THC from CBD. The policy team felt it was really appropriate to take a deeper dive into the issue associated with the legality of production in this manner, and so that's really where the focus went. So since the discussion in June, our team has been analyzing the statutory language, beginning from the foundations of producing a controlled substance identified in RCW 6950. So we analyzed definitions and identified the privileges in statute, and found a clear understanding of how these issues relate to licensed processors specifically. One primary area of focus involved activities falling under what's called the safe harbor provisions in RCW 6950-363. So this is a statute that affords protections against prosecution if people are working in compliance with the exceptions provided in state statutes. So it still remains illegal to manufacture a controlled substance in Washington state, except for when you're licensed and you're following the privileges set forth. So as all producing of a controlled substance continues to be illegal, we needed to focus on those exceptions to figure out what the legal production, processing, and sales looked like in fine detail. So each license type allows for specific activities. A licensee can engage in and be protected from prosecution under those safe harbor provisions. And so as we explore the differences in the license types, we identify that processors are not afforded safe harbor for the activities of creating Delta-9 THC, and that the licensed processor, or I'm sorry, the licensed producers, let me clarify that, the licensed processors are not afforded that activity, and that only licensed producers may grow cannabis for that purpose. Processors are allowed to purchase Delta-9 THC from a licensed producer, but not create their own Delta-9 THC. So when you review the analysis that was provided, you'll see the details in the document. So I did have a chance to speak with each individual board member independently and got some feedback, and we tried to address the issues over the time that was raised. And so we believe we have a very sound analysis. I think we have clear direction. I know that not everybody will probably agree with this in the industry. However, this is a very substantial legal analysis that we've created through analysis, and we really believe that this is the appropriate and objective path forward. So at this point, we're finalizing the document. That's what we're sharing with you today is our final document and conclusion of that analysis on the processors. We will be continuing to notify the licensed community through listserv and gov delivery, providing some additional information potentially through the other divisions on how they may operationalize this. So I would like to include Director Brady from the Enforcement Division to kind of outline what her thoughts are around some of the notifications from the overall approach of this interpretive statement. So Chandra.
Good afternoon. Thank you, Justin, and thanks to the board members and board chair. I just wanted to identify that we're working behind the scenes to develop a communication so that we're able to communicate the enforcement approach with the industry and our officers. And we're going to use the same approach as is our standard. We're going to approach this from an educate first perspective so we can help people get on the path to compliance. We have several tools there. We have basic education. We can use administrative holds, warnings, notice to correct. And then if we identify that we have folks who don't indicate they want to get on the path to compliance, we also will step into the lane of enforcement action.
Excellent, thank you. So we'll be having some of those follow-up communications come out from the agency in the near future, so we could provide that clarity to licensees across the board. And I would, as far as provisions go, and it's not detailed in the analysis because it was really focused on the processor side, but I would add that the retailers need to keep in mind that they are only legally able to purchase product that was legally produced in Washington. So if they have knowledge about product that was not legally produced in Washington, they shouldn't be buying that product from those processors. So that's something that didn't get fully explained in the analysis because we were really focusing on those privileges, but we do want to recognize that this is not just an independent area of consideration. There will be continuing dialogue on these issues as we continue to explore these. We have the open rulemaking project. We're also looking at legislative requests over the next year, and all of these conversations around these types of issues we're trying to explore and vet in there. So the interpretive statement is where we are at in this, the current legal standings and statute. Again, I believe it's a strong foundation and an objective look at what is legal for our licensees and what is not. And so with that, I'm happy to answer any questions from the board.
Great. Thanks, Justin. One quick one for me, and then I see Member Garrett has a question as well. When you talk about the safe harbor and we're talking about processors in this conversation, that doesn't mean that a producer could do that, right? They would be under the same lack of privilege to do this. There is no way that a licensee in Washington State can convert hemp into Delta 9, correct? There's no safe harbor for that.
That's correct. And so, by no means is this to infer that a marijuana producer licensed by the board has that legal authority to convert the CBD from hemp into Delta 9. The provisions of producing really seem to focus around the growing aspect of the cannabis plant for the purpose of quote unquote marijuana under Washington state law. And so, we didn't do the incorporation of that full analysis into this area because the primary focus that we wanted to address in as timely manner as we could is the processor activity that was explained and described to us in previous meetings.
Correct. Okay, thank you. Member Garrett, go ahead.
Okay, did I just hear, and I just want to, for clarification with enforcement, are we saying if there are folks out there that knowingly has done this, is doing this, we're going to just start out with educating them? Is that what I'm hearing?
No,
Go ahead,
that's not
Director
what you're
Brady.
hearing. That's not what you're hearing. Thank you for the opportunity
Okay.
to clarify. We just want to, there's a difference between folks that are on the path to compliance and folks that are specifically choosing not to comply with the rules and laws.
Okay. I just wanted clarification because of how that sounded.
I understand. We're going to be publishing a document within the next week that is going to make clear enforcement's approach to this topic. So,
Okay.
So,
Okay.
some sort of enforcement bulletin or something? Is that what you mean, Director Brady?
yes, Chair. I have to
Yeah.
actually click the unmute button. Thank you.
Okay, great. Thank you. Okay. Other questions? Then my only question back to Justin then to make sure that I and everyone is understanding this. You know, this is really, it's focused on the processor piece because that's where we've been hearing about it. But this same safe harbor theory would be for anybody trying to use this process, whether you call it synthetic or transform or convert or anything else. There is no safe harbor in Washington State's 502 regulated market to go from hemp to Delta 9. Do I have that right?
Yeah, I believe so, because if you're looking at the safe harbor provisions in statute, it really talks about some of the activities that are afforded. So this is very similar to the alcohol laws post-prohibition. So it still continues to be illegal to manufacture alcohol in the state of Washington without a license. Same thing here in cannabis. It's illegal to manufacture, produce, process, sell cannabis without a license in the state. And so the state has afforded opportunities and privileges to those who get a license, and there's nothing that's described in those license privileges that appears to allow that particular practice. So when we're looking at that, especially with the processor license, the processors only have the legal authority to process the product, not actually create Delta 9.
Okay. And there was a public acknowledgement that there was a investigation underway related to this issue. Does this interpretive statement in any way impact that ongoing investigation?
No, this is a basically the agency interpretation of the legal issues. This has nothing to do with an investigation, so it's really independent of that. You know, we had these issues raised, and we needed to clarify for our licensees and staff that this is what the law states, and so everybody has that mutual understanding. The law hasn't changed. This doesn't change how the law was written or applied. This is just providing that clarification because we did see that there was a lot of differing opinions about this, and that's what the new policy shop is really geared towards. Is when these types of issues come up, we want to provide clarity from the agency level, and that's what facilitated this. So this really has nothing to do with any investigations, and if there's something going on with that, completely independent in the enforcement area.
Okay, great. Thank you for that. I want to turn it back over to Rick, but just check again if there's any further questions from the board for Justin or anybody else on staff. Seeing none. Director Garza, anything you want to add or have anybody else from your team add to this conversation before we get ready to adjourn?
Well, I'd certainly provide them that opportunity, staff, since the board is present, to provide any other information. But I think you heard it all. One, that we needed a little bit of time and some help in the Attorney General's office to better understand our authority. And I think we'll be communicating that. Brian will be sending out a communication today. And then, as was said earlier, enforcement will work on whether we want to call it a bulletin, but communication out to licensees to help them understand what this means. And then I think you said it earlier, this is really separate from the investigations that are occurring with respect to specific other licensees, and which we have to separate. But I think this gets us in a place where we now feel comfortable that we can share what the position of the agency is regarding the creation of this specific been referred to as synthetic Delta 9.
And this interpretive statement is going to go to every licensee, not just processors, right?
That's right.
So everybody will know this is not something that we accept. Okay.
Correct.
Yeah, and if I could, just to circle back to your previous question, Chair Postman, just for clarification on this, You know, we certainly, and it's in the document that people will be able to see and read. But we need to really make it clear the licensed processors may not sell or purchase any THC product not legally produced by a licensed marijuana producer, which means that a processor should not be selling it not only to retailers but not to another processor for further integration into other products. So I just wanted to make sure that we stated that verbally, so that's clear as well, but it is in the document, and if there are questions, I'd be happy to answer those as well post-meeting.
Okay, great. Okay, then seeing no other questions, thanks particularly to you, Justin, for the work on this and leading the team that did it. And I'll also say I know that it's not over that work. We have rulemaking going on. We've talked about legislation for the 2022 session. There's an ongoing investigation. There's an enforcement bulletin on its way or something of that sort. And so I just thank you to the staff for all the work on this. And I would just, obviously we're going to have to stay on it and be vigilant and deliver all those other pieces as well. So thank you for getting this together on short notice. And we will now adjourn the special caucus meeting for July 22nd, 2021. Thank you.